This is the Neoliberal Around podcast.
Welcome to another episode of the Neoliberal Journals podcast, and those watching on YouTube channel. I'm Renaldo McKenzie, your host and creator and commentator. We have breaking news update. Fifth Circuit withdraws opinion in John Anthony Castro's case, then issues a new ruling. There has been a significant new development in John Anthony Castro's fight for freedom. On Friday, the US Court of Appeals for the Fifth Circuit withdrew its previous opinion and granted rehearing in Castro's federal case. A development, Castro argues, validated serious legal deficiencies he had identified in the appellate court's original reasoning. But by Monday, August 17th, 2026, the situation had shifted again. Rather than granting Castro the relief he believes should follow from the problems with the original opinion, the panel issued a revised position attempting to preserve the result while changing portions of its reasoning. In our latest conversation with Castro, the former Republican presidential candidate described the extraordinary sequence of events and explained why he believes the substituted opinion creates new legal problems rather than resolving the old ones. From withdrawal to a substituted opinion, of course, the central dispute concerns a sentencing enhancement imposed on Castro for allegedly exercising a leadership role in criminal activity. According to Castro, the Fifth Circuit's original opinion reasoned that the leadership enhancement could stand without a finding that another person was criminally responsible. Castro attached that reasoning in his petition for rehearing. Of course, his argument was strikingly simple. How can someone legally be considered the leader of criminal activity if the government and district court never established another criminally responsible participant whom he led? Now, as Castro summarized the problem during our interview, the original reasoning effectively made him, and I quote, a leader of no one. Then came Friday's dramatic development. The panel withdrew its opinion and granted rehearing. For Castro, the withdrawal was an important acknowledgement that something was seriously wrong with the original decision. It is important, however, to distinguish withdrawing or replacing an opinion from a judicial admission that the court was legally wrong on every disputed issue. So the precise meaning of Friday's order must ultimately be determined from the language of the court's order itself. So what happened next is where the controversy deepened, because by Monday the court has changed its reasoning. The Fifth Circuit had issued a substituted opinion. Now Castro argues that instead of correcting the underlying problem, the panel attempted to strengthen, or in his words, beef up its reasoning by adding a new rationale. Now, according to Castro's description of the substituted opinion, the panel now reasons that based upon the record as a whole, it was plausible that at least one other person was involved or criminally responsible. But Castro says that creates an entirely different constitutional and appellate problem, because where did that factual finding come from? And of course, Castro argues that the district court never expressly made the finding upon which the appellate panel now relies, and that distinction could be crucial. Now, of course, John Anthony Castro joined me earlier. We recorded the conversation. It's available right here on the Neoliberal Journals podcast, and we're going to play the entire interview for you, where I sat with him And of course, there is an article is available in the Neoliberal Journals at the neoliberal.com, and also in the Neoliberal Post at renaldocmckenzie.com. But I just wanted to make a very important point here that Castro calls what happened appellate, what has happened. Well, what the appellate court is, the Fifth Circuit is doing, he is calling it an appellate fact finding. In other words, according to Castro, the Fifth Circuit repaired one hole in its opinion by opening another. They withdrew it, then tried to beef it up. And you're going to hear him say that in the interview. And he believes Friday's withdrawal demonstrated the strength of his challenge. And he says the Fifth Circuit had approximately 20 months to consider the appeal. Yet after he attacked the opinion through the petition for rehearing, the panel withdrew it. But Castro argues that Monday's substituted opinion did not resolve the fundamental issues. Instead, he says the panel changed its rationale while continuing to reach essentially the same results. And of course, his accusation is serious, that the appellate court is working backward from a predetermined outcome, affirming his conviction and sentence, and searching for legal reasoning capable of sustaining that outcome. So that remains that Castro's allegations, not an established finding concerning the motives of the Fifth Circuit judges. So, of course, there's also the issue of Linda Rivera's evidence, the impeachment of evidence of motive and bias, because Castro continues to challenge the Fifth Circuit treatment of evidence involving government witness Linda Rivera, and according to Castro, information concerning Rivera's potential exposure to criminal protection and alleged favorable treatment of immunity should not have been treated merely as general impeachment evidence. He argues that it was evidence of something much more important, motive and bias, in the sense that the distinction matters because evidence suggested that a government witness had something to gain from cooperating with prosecutors may bear directly upon the witness' incentive to testify. And Castro argues that the Fifth Circuit improperly blurred ordinary impeachment evidence together with evidence demonstrating motive or bias, and that this treatment conflicts with treatment court precedents governing disclosure of evidence favorable to a criminal defendant. And of course, he maintains that the issue implicates the government's constitutional disclosure obligations under the Brady versus Maryland and related cases. So whether Castro can establish a constitutional violation and whether undisputed evidence was suppressed and sufficiently material to require relief remains, of course, for the courts to determine. But why were Castro's Trump lawsuit part of the case? That was my question, and I did ask him. And that remains difficult to ignore, because what does Donald Trump have to do with John Anthony Castro's federal tax prosecution? Before his incarceration, Castro was a Republican presidential candidate who brought litigation seeking to prevent Donald Trump from appearing on presidential ballots under Section 3 of the 14th Amendment. Castro argues that his lawsuits involving Trump and IRS personnel were improperly characterized as evidence of obstruction. And he counters that filing lawsuits and petitioning courts are exercises of constitutional rights, and that lawful litigation cannot simply be transformed into criminal obstruction because the government dislikes the litigation. And that was my question to him. The Fifth Circuit's treatment of that issue is therefore another component of Castro's continuing challenge. And it raises a broader constitutional question. Where is the boundary between genuine obstruction and the protected exercise of citizens' right to petition the courts? Where? So, of course, Castro has filed another challenge. He is not accepting Monday's substituted opinion as the final word. He told the Neoliberal podcast that he has already responded with extensive filings seeking further review. According to Castro, those filings exceed 120 pages and include requests for panel rehearing en banc, and publication of the decision. Now, rehearing en banc would potentially place the case before a larger complement of Fifth Circuit judges rather than leaving the disputed issues solely with the original panel. Castro is also preparing for the possibility that the battle will eventually move beyond the Fifth Circuit. And of course, I did ask him about that. If necessary, he says he intends to petition the US Supreme Court for certiorari. And of course, Friday changed the whole story. Friday's withdrawal matters, but we should describe precisely what it establishes. A withdrawn appellate opinion is not standing alone proof of corruption, political retaliation, prosecutorial misconduct, or Castro's innocence. Nor does granting rehearing necessarily mean that an appellate court has conceded every argument made by a defendant, but rather should the development, but neither should the development be casually dismissed. When an appellate panel withdraws an opinion following a petition challenging its reasoning and then issues a substituted opinion addressing disputed points differently, the change itself becomes part of the story. So the question now is whether the substituted opinion actually cures the legal deficiencies Castro identified or merely reaches the same destination by another road. So Castro believes that it is the latter, and he intends to keep fighting. The fight for freedom continues because during the conversation, Castro remained remarkably determined. He believes his faith will sustain him through incarceration and through what could become a lengthy appellate struggle. He believes the truth will ultimately emerge, and he has authorized the Neoliberal Run podcast to continue sharing his conversations and documenting his fight. We will do so. We will do precisely that, ladies and gentlemen. But our responsibility is larger than advocating for one individual. It is to ask individual questions of powerful institutions. America was not founded upon the proposition that government officials are beyond scrutiny. Its constitutional experiment rests upon precisely the opposite idea. Power must remain accountable to law. Judges must follow the law. Prosecutors must follow the Constitution. Defendants must receive due process, and journalists and citizens must remain free to question all of them. John Anthony Castro may ultimately prevail on some of his claims and lose on others. Determination belongs to the courts and must be based on the actual record controlling precedents and, of course, constitutional law. But when an incarcerated man challenges the machinery of the federal government and an appellate court withdraw an opinion only to return days later with altered reasoning, there is a legitimate public interest story to follow. We are following it. The fight did not end Friday. It did not end Monday. And John Anthony Castro says he is prepared to take it all the way to the US Supreme Court. The fight for freedom continues. And just an editor's note, this report incorporates statements by John Anthony Castro during an interview with me, Renaldo McKenzie, for the Neoliberal podcast and the Neoliberal Journals and the Neoliberal Post. Now, allegations concerning prosecutorial misconduct, witness agreements, transcript alterations, political retaliation, judicial motives, and improper appellate fact findings are Castro's allegations and legal arguments, unless independently established by court records or judicial findings. I'm Renaldo McKenzie of the Neoliberal podcast, and of course, we have the full recording, the full interview that I had with John Anthony Castro. It is available right here on the Neoliberal podcast and on the Neoliberal YouTube channel. What good?
This is the Neoliberal Podcast.